Welcome to Law and Crime's Daily Debrief, everybody. Actress Loughlin and her fashion designer husband, Massimo Giannulli, are accusing the FBI of bullying witnesses in their college cheating scandal case. In recent court documents, the defense for Loughlin and Giannulli says the mastermind of the operation, Rick Singer, lied in order to drag down wealthy parents and their children rather than take the blame for himself. The defense is also accusing the government of hiding evidence from the defense, including notes from Singer's iPhone. Singer's notes indicate that FBI agents yelled at him and instructed him to lie by saying he told his clients that their payments were bribes rather than legitimate donations that went to the schools, the documents say. They further note the government's desire to nail one of the defendants at all costs. A trial date in this case has been set for October. Two attorneys are with us tonight here on the Debrief to discuss this and other cases. Dina Dahl is an attorney and trial mediator in Los Angeles. Mike Korobanix is a former prosecutor who now practices federal criminal defense law in New Jersey. So, Mike, let's break this all down. My initial thoughts are, first of all, whether we like it or not, the government can lie during investigations. That seems well settled. Second, though, this seems to be part of a script where the FBI appears to have been trying to use Rick Singer to get an admission out of the others. Singer was pushing back, saying, no, this tactic won't work, try another tactic. Can Loughlin and her husband actually use this to their advantage, or if they try that, is it going to backfire?
I think they better proceed with caution. I think that he's going to be subject to cross-examination. The fact is they turned over these notes. And I think when it bears out, Aaron, you're right on point, is this is someone who's given the feds some pushback in their preparation of their investigation. But the bottom line is there's so many different surrounding circumstances. I think it's much to do about nothing.
Dina, do you agree or disagree with my assessment and with Mike's assessment?
You know, I have to say I disagree in that I actually think this is going to impact the defense quite a bit. I mean, the fact is that these notes were taken at the time of the conversation, which gives them more credibility. It's not as if Singer is saying months later that this happened. And the fact is, we know this happens. Like you said, investigators can lie, and we hear about coerced confessions all the time that happen as a result of investigators lying. And I think the public kind of understands this, and this is going to be big for the defense.
The defense, Dina, filed these notes as part of a request to compel discovery, but the government is the one who turned over the information in the first place, though, after Rick Singer's team agreed to waive privilege on the information. So did the government screw this up, or is just this the way it has to be done?
Well, it sounded like we heard that this was coming back in December, right? And they're giving this instead on the eve of what was going to be a set for trial. So the government, did the right thing by turning it over, but they waited until the last possible second.
Well, last possible second, but we have a trial in October, so that's how many months away at this point. Mike Korobanix, is this just how it's done, or is there a legitimate complaint here that the government took too long to hand this over?
I don't think there's I don't think there's a legitimate complaint. I think sometimes as adversaries, especially in the federal courts, you try to resolve any issues between the defense and the government. They did turn them over. There is time. Technically, in federal court, under a lot of the federal rules, is you're not entitled to statements technically till after direct examination. The courts have said that's really out of date and we can't do that. But I think they handed them over in plenty of time and they'll be able to work with them.
A bit of disagreement on this issue here on the Debrief tonight. Let's move on, though. Harvey Weinstein dropping his fight to be released on bail before he's sentenced to prison. His publicist says an appeals court is unlikely to rule favorably, and if it does, it would open up Weinstein to extradition to Los Angeles on criminal charges he faces there. Weinstein's defense team says Weinstein is focused on the future from a New York hospital room where he remains. Once he leaves, he'll be in jail in an infirmary unit at Rikers Island in New York. There, he'll reportedly be confined to a wheelchair. Authorities won't let him use the walker he used to go in and out of his courthouse for fear that the walker could be used to conceal weapons. Weinstein's sentencing is set for March 11th. Authorities in the state of Idaho are making plans to bring Vallow back to their state to face felony charges there. A transport date of March 4th is set in that case. Vallow is accused of not supporting and deserting her children. She's decided not to fight extradition from Hawaii, where she was arrested. Her husband, Chad Daybell, is not charged in the case. He visited Vallow in jail recently and refused to comment on her ongoing legal matters. Authorities in Milwaukee, Wisconsin have identified 51-year-old Anthony N. Farrell as the gunman who shot and killed 5 people at work yesterday before killing himself. The 6 deaths occurred at the Molson Coors brewery, which produces Miller beer. Farrell was reportedly an electrician who had been with the company for 17 years. Sources who refused to give their names told the Milwaukee Journal-Sentinel that Farrell complained of racial discrimination at work and that he had a long-standing disagreement with one of the victims. 1,000 people work at the sprawling manufacturing and office facility where the shooting happened. Also in Wisconsin, a father is on trial over charges he shot and killed his own son after a night of heavy drinking. 44-year-old Cal Fleischauer is being tried again for second-degree reckless homicide. His 19-year-old son, Chase, died from a gunshot wound to the head. Prosecutors blame the father. The father says Chase accidentally shot himself. The father is being tried again because the jury in his first case started conducting experiments to test the state's evidence, and of course, that's not allowed. The human toll this case presents has been clear from the testimony. The victim's sister heard a commotion in the overnight hours, ran to find her brother shot in the head, and called 911.
That it was just, there was Chase there, and he was lying on his back by himself. And he was bleeding really badly from his head.
I think that my brother was shot in the head.
You think your brother shot himself in the head?
Please, please,
Okay, I've got help on the way. Are you there with him now?
please.
First of all, are you there with him now?
Yes, I
Okay. And where's the gun?
told him something, something.
Summer? Summer, is he awake?
No, he's not.
Okay. Is he breathing?
I don't know how to tell.
Okay. You don't think he's breathing though?
No, I do.
Okay, we're going to help him.
Deputies arrived after that 911 call. The victim's sister begged them to help save her brother. Their discussion was captured on police dashcam recordings.
Summer, and she...
Summer,
Please help me.
Summer,
Please.
Summer, come sit down.
Okay, but it's fine, but you start doing them then.
Summer,
Okay.
Summer, come sit down. Okay.
I don't like this.
Summer.
Please help me.
Summer.
I don't care. I'm fine. I'll stay here. Please, please, okay.
EMS is on their way.
Please help me. You can't breathe.
Summer.
One, two. I'm really fine.
Sean, where's the firearm that was used?
And they're trying to find come on, son.
Did this happen in a bedroom?
No, it's just what the fuck you tell.
Please, sir. Please help me.
They are almost here.
EMS paramedics arrived shortly thereafter and pronounced Chase Fleischauer dead. Their discussion with the victim's sister was also captured on recordings played in court.
My brother needs me. My brother is by himself. You let him die like that. You let him die by himself. My brother needs me. He needs me. I need him. I can't live without him.
We gotta stay out here until they figure out what happened, okay? Summer.
Nobody's gonna bring you back here to the hospital. Anything.
There's nothing that we can do for your brother right now.
He's my brother.
I know.
He's 20 years old. He was not until he was 94. A psychic coach him that until he was 94 years old. I'm supposed to die for him way before my brother is. This is ridiculous. My brother is not dead.
Honey.
Where is my brother? My brother is fine. My brother is fine. You don't know that? You do not know that. He is fine.
One of the victim's college roommates recalled how everyone was looking forward to graduating before Chase died.
I mean, we had classes together, so we'd walk to class, do homework together. We, grocery shop together, played video games, played sports. We'd go outside, toss pigskin around.
How was Chase in regards to schoolwork in relation to you?
Yeah, he was a very hard worker, and he was always a smarter kid, so we always pushed each other.
What were his goals that he had for work when he graduated?
Yeah, so like I said, he was a business major, so he definitely wanted to own his own business. He didn't want to work for anybody, and he actually basically wanted me to work for him, so.
In any of the activities that you and Chase did together, did any of them ever involve firearms?
No.
In all of your time being Chase's friend, companion, roommate, had you ever seen him, been involved with, or in any way mentioned to you anything about firearms?
No.
The defense tried to call the victim's character into question while cross-examining his former girlfriend. The defense asked the girlfriend if she drank alcohol with the victim while they were dating in high school and into freshman year of college.
No.
None?
On dates, no.
Well, did you ever drink alcohol with Chase Weishauer?
Judge, I would object to relevance. Did she drink alcohol with Chase Weishauer?
Well, I'm going to overrule. It's a matter of weight. If any that the jury gives it, you can answer.
I have before, yes.
All right. Before Chase Weishauer's death, how many times did you say you saw my client?
I want to say 2.
2?
Yes.
And where were those at?
At his house and then at Chase's graduation.
So I take it, did you know about the Jeep that Chase Weishauer is planning to build with his father in the summer of 2018?
No, I did not know that.
Let's turn to our panel one more time on this case. Dina Dahl, got to ask about Evidence Rule 412. In the federal system, the defense can use the victim's character, but the prosecutor can both rebut it and offer evidence of the defendant's same trait. So here, you've got accusations of drinking going on. If the defense is trying to say, well, the victim was drinking, can the prosecution turn around and then hammer the defendant saying, no, he also had issues with alcohol?
Yeah, it's interesting that they are making this such a big point because the defendant was so intoxicated when the police came. That was really the reason why he was called into question and so suspicious. And so why care so much if the son is drinking also? It sounds like we kind of know what happened there, right? They were too aggressively playing. I mean, in my view, that seems to be what it is. I don't think the drinking is that much of a point.
Okay, Mike Korobanix, does the drinking somehow come into this as potential defense? Because you can in Wisconsin turn around and say intoxication can result in failure to form criminal intent here. But it doesn't seem like they're even going there. Where they're going is to just turn around and say, no, the defendant wasn't the one who had the gun and pulled the trigger.
It's this drinking, I agree with Dina. This just seems to be such a non-factor in a certain sense here when you're trying to put it on the victim, like it's his fault that he was drinking and that he got shot. Whether he did it himself or not, I just don't see it. It's almost like victim shaming in a way, and I just don't see how it's helping the defense. They should be concentrating on their client and what proofs they have against him, and proving that this young man, who unfortunately was killed one way or another by his intoxication, is really, I don't see where it's going other than hurting the defense.
Yeah, I think we need to have a stronger point made. We're going to get back to that case in a minute. Still ahead, though, here on the Debrief. After decades and decades of failed attempts, Congress takes action against an old criminal ill of the nation's past. Then we're going to head back to that trial of the Wisconsin man accused of shooting his son in the head after, as we said, a night of drinking. Father says the shooting was an accident. More on that case is after the break. After 130 years of attempts, the House of Representatives has finally passed a federal law which criminalizes lynching. These images are from museums dedicated to the memories of lynching victims. The House vote was 4-10 in favor, 4 representatives voting against the bill, which was named in honor of Emmett Till, who was lynched in 1955 at age 14. Illinois Representative Bobby Rush, a Democrat, said lynching was an act of American terrorism and that it is never too late to repudiate evil. President Trump is expected to sign that measure. Law&Crime is preparing to cover the upcoming murder trial of real estate heir Robert Durst. Durst is accused of killing his friend Susan Berman because she knew he had previously killed his wife Kathy Durst. That's the state's theory of the case. Law&Crime Network's coverage of the Robert Durst trial begins March 2nd. Cameras are allowed for only parts of the proceeding. We'll bring you as much as we can under the judge's guidelines. Let's head back now to the Wisconsin prosecution of Cale Fleischhauer. Investigators tested the gun the state says Fleischhauer used to kill his son to see whose DNA was on it. It's an attempt to determine who actually fired the weapon. The state demonstrated this process on a replica firearm in the courtroom.
I took a swabbing from each of the sides of the firearm, kind of down on the handle.
And what were the results of the DNA analysis that you did on the grips of that firearm?
I found a mixture of at least 4 individuals from that swabbing, but due to the amount of material and information that I had, I was not able to do any conclusions on that profile, so I was not able to compare it to anybody. I tested from the ridges, like the raised portions of the slide on each side. I took one swabbing from both different areas.
And what was the DNA result of the swab of that firearm?
I found a mixture of at least 3 individuals from that swabbing, which included at least 2 male individuals. But on this profile, I was not able to conclusively say who was included into that profile. Chase Fleischhauer was inconclusive, along with Cale Fleischhauer. So I was not able to say if they were included or excluded. That I just don't have enough information. The slide area was locked back, exposing a portion of the barrel. I took a swabbing from around that, about a ½ inch around on all sides, to go just around the barrel. A male STR DNA profile was developed, and Chase Fleischhauer is the source of that profile.
The defense wanted to know how victim Chase Fleischhauer's DNA wound up on the barrel of that firearm.
That DNA either came from saliva, blood, semen, or touch, correct?
I couldn't tell you how it got there, but...
Those are the sources of DNA, correct?
Those are the possible sources, yes.
And you did not see any blood on the barrel, correct?
None that I noticed.
And that would mean touch DNA, correct?
It's possible.
The defendant's blood was tested 10 hours after the shooting and measured .195. A toxicologist calculated what his blood alcohol level would have been at the actual time of the shooting. She gave 3 different estimates, averaging about 10 times the legal limit.
The slow elimination rate is 0.010 grams per 100 milliliters per hour.
And what would that lead for a blood alcohol result?
That would leave at 4 a.m. an estimate of 0.293 grams per 100 milliliters of ethanol.
What about at that average rate of elimination?
The average rate is 0.015 grams per 100 milliliters per hour, and that would produce an approximate ethanol level of 0.342 grams per 100 milliliters at 4 a.m.
And finally, what about a fast elimination rate of alcohol?
A fast elimination rate is 0.025 grams per 100 milliliters per hour and would produce an approximate ethanol level of 0.440 grams per 100 milliliters.
In earlier testimony, one of the responding officers said the defendant was, shall we say, a strange suspect.
And I still had my camera on me, and I noticed there was some blood on the defendant. I started taking photographs. He started to become upset and loud. He was getting loud and exaggerated. He asked if I wanted to start something, I believe is what he said. He called me sunshine, and then he asked if I wanted some of his, he said cock, and he pulled down the front of his pants, exposing his penis multiple times. I told him to stop, and he continued to pull down his pants. He was yelling. He was showing odd behavior, and then he made an aggressive right turn towards me.
What's an aggressive right turn, officer?
Quick, without any warning. And then I believe he started to raise his arms when, at that point, Deputy Coleman and Deputy Proshak made a decision that for officer safety, he'd be detained in handcuffs.
All right, let's bring everybody back in to discuss this case. Dina Dahl watching from California. What's this guy's deal? We got .293, I think is the lowest number I heard there. That's really a high blood alcohol level here.
Yeah, it makes me wonder whether or not he even remembers anything for the night. I mean, it sounded like he acted extremely strangely to the officer. And you do have to wonder, does he even remember what happened? It seems to me that the DNA in the barrel that you mentioned earlier, there's a lot of inconclusive evidence here, and part of that might be his own recollection of it, actually.
Yeah, I mean, we've got the victim's DNA on the barrel, the front of the barrel here. Dina, does that necessarily tell us anything? Because it's clear that it was the victim who was shot, and it's the victim's DNA on the front of the barrel. You put two and two together, that makes sense. It doesn't give us any definitive answer, I don't think.
No, exactly. And what could have happened is the gun could have gotten passed back and forth a few times before it went off. It's not that helpful, I don't think, to the jury.
Mike Korobenix, does the state have a good case here or not?
I think it's a weak case because it's just there's just a lot of unanswered questions. I mean, he was saying 2 or 3 different sources of DNA. Can't say who the DNA is. But I've got to tell you, that last picture they showed just before we started talking of his hand with blood on it and handcuffs, I think is powerful and puts him at least in the proximity. But it's tough being a defense attorney when your client doesn't remember what happened.
Well, you know, Mike, the complaint that we heard out of the defense through the course of this case was, hey, look, I mean, the defendant could have gotten the blood on him from basically trying to render aid in the process of this. That doesn't necessarily mean that he's the shooter.
Well, it's very inconsistent, though, that he was rendering aid, and yet when the police came, if he was rendering aid, it would show he had some concern about the condition of his son. But when the police came, the people who could help his son in any situation here, he did nothing but confront them. I think it looks bad for him at this point.
And he's said to have basically tried to prevent the sister from calling 911 as well. So is that just a drunken reaction, or is it consciousness of guilt? The jury's got to try to wade through that and make a tough determination. Appreciate the insight. Mike Korobenix, Dina Dahl, right here on The Debrief. We'll be back with our recap of the day in court tomorrow at 5 o'clock Eastern, right here on the Law&Crime Network.